Hello and welcome to the second of our sessions on employers' liability and public liability claims. If you did miss the first session, that's available on our website as a recording, and this one will also be posted there as well, so people can access after the event. So if we can just start, there's our heading for the day. I'll just start with housekeeping. So everyone's cameras are automatically off. There is a Q&A box on the platform, which can type questions that we'll do our best to get to as we go along. Or if not, we'll try and leave some time at the end just to deal with any questions then. Again, everyone's microphones are automatically off. So as I say, the Q&A box is the way to ask your questions. Any technical problems, as per the suggestions there, please check your device settings, and if all else fails, log off and log on again. And that usually does the trick. As I mentioned, the session is being recorded, so we'll be available to view for others after the event, and we will be asking for feedback afterwards. Just obviously, we always like to try and learn from any feedback we can. So if I can now introduce our speaker for the day. Today's session will be more detailed in terms of the common types of claims that we deal with. And I'm pleased to say that Doug Denton, a barrister at St John's Building, will be giving the talk. You should all be able to see his bio, but just for those who don't have that there, Doug was previously employed at the Home Office prior to being called to the bar. Following call to the bar, he completed a Master of Law degree at the University of Cambridge. Thereafter worked in the corporate and commercial litigation departments of a leading commercial law firm. Doug has developed a practice at the bar encompassing commercial litigation, medical negligence, professional negligence, personal injury, and industrial disease. And as he says, in addition, he's regularly instructed on catastrophic injury claims and those of utmost severity. So without further ado, if I can pass over to Doug to commence the talk.
Good afternoon. As Ian's indicated, I've been asked by Ian and the team to do a talk on employers' liability and public liability, with particular emphasis on manual handling, assaults, patient on staff assaults, personal protective equipment and defective equipment in general, together with slips and trips and needle stick injuries. Now, clearly, in the context of an employer-employee relationship, the establishment of a duty is taken as read. But in the context of an employment, an EL case, the claimant would have to establish breach on behalf of the employer, the defendant, and that the defendant's conduct did in fact result in the damage alleged, and that the damage wasn't too remote in as much as the damage was reasonably foreseeable. In addition to which, there'll be issues of contributing negligence, which always arise in cases of this nature. Now, in terms of the duty is non-delegable in nature. And so the employer can delegate the performance of the duty to others, whether employees or independent contractors, but cannot delegate responsibility for its negligent performance. Now, I've cited the case of Wilson and Clyde, which a great many of you will be familiar with that case. Now, in that particular case, the employer had entrusted the task of organising a safe system of work to an employee, and through his negligence, another employee was injured. The employer could not have been held liable for its own negligence, since it had taken all reasonable care in entrusting the job to a competent employee, nor could it have been held liable vicariously, since common employment would, as the law stood at the material time, have been a defence. So the basis of the decision was that the employer was liable for a breach of a personal duty to the claimant to see that care was taken by the person whom they employed. Liability is negligence-based rather than strict. That is, to take reasonable care to see that the employees are safe, and what that requires will vary with the nature of the risk. And although performance of the duty may be delegated, the duty to take reasonable care remains the duty of the employer. Now, it's often explained under four heads, which derives from the case of Wilson, and that is safe staff, safe equipment, safe place of work, and a safe system of work. And hopefully I'll deal with the four limbs to that. In terms of safe staff, the employer's duty to its employees is to employ competent fellow workers. And that is illustrated in the case of Hudson and Ridge, case decided in 1957. The defending company was held liable in those circumstances on that ground for continuing to employ a man who was known to be addicted to acts of horseplay and by such acts had injured the claimant. Now, the duty extends to the appointment of staff who are independent contractors, so that if an employer negligently selects an independent contractor or employs an insufficient number of contractors with a resulting injury to an employee, it will be in breach of its personal duties to the claimant. Again, illustrated in the case of Waters and Clark. In the case of Waters, the House of Lords treated the police officer's status as analogous to that of an employee and considered it arguable that there was a breach of duty where an employer knew that acts done by employees during their employment might cause physical or mental harm to a particular fellow employee and did nothing to supervise or prevent such acts when the Commission had the power to do so. And similarly, in Clark and Chief Constable of Essex, the defendant Chief Constable was held liable in negligence to a police officer who had been caused foreseeable mental and physical harm through bullying, intimidation, and unlawful use of disciplinary proceedings. One route of this was through vicarious liability for the acts of police officers, and another was through the defendant's own duty to provide a safe place of work. Now, in terms of safe equipment, responsibility for the safety of equipment provided to the employee is governed by the Employers' Liability Defective Equipment Act 1969. And I set out the narrative to that there. You can see where an employee suffers personal injury in the course of his or her employment in consequence of a defect in the equipment provided by his employer for the purposes of the employer's business, and the defect is attributable wholly or partly to fault on behalf of a third party. Whether that third party is actually identified or not, the injury shall be deemed to be also attributable to negligence on the part of the employer. And you will note under subsection B, the issue of contributing negligence can still be raised by the defendant employer. Now, the statutory duty is expressed as being non-delegable, and so an employer is made personally answerable in negligence if the employee suffers personal injury, firstly, secondly, in the course of his employment as a consequence of a defect in the equipment, which has been provided to him or her by the employer and for the purposes of the employer's business, and the defect is wholly or partly at the fault of a third party. Now, this is illustrated in the case of Carr and Brands, case decided in 2022. In that case, there was liability under the 1969 Act in respect of a defective vehicle which had been provided to an employee, but it was subject to a 40% deduction for contributing negligence, since the absence of an inspection as required by the regulation was partly, but not exclusively, due to the claimant's fault. So you can see there the operation of the 1969 Act. Now, in terms of maintenance of equipment, the obligation to provide and maintain proper plant and appliances is a continuing obligation. Now, the duty isn't absolute. There has to be fault. So an employer, for example, isn't liable for a latent defect due to nobody's fault, and which cannot be detected on a reasonable examination. Similarly, if an employer knows the equipment is dangerous and does nothing about it, the employer will be liable in those circumstances. And there'll also be liability if the employer retains in use a piece of equipment known to be defective. Now, the employer will not be liable where it would be reasonable to leave the employee the task of selecting the equipment, and nor where the employee fails to make proper use of the equipment, provided, and this is the caveat, in both of those examples, the employee had been given adequate instruction as to the selection and use of the equipment. Now, effective maintenance may require both a system of inspection and or defect reporting and a system of withdrawing the defective equipment from use for repair or replacement. Now, in terms of the safe place of work, there is a duty to see that a reasonably safe place of work is provided and maintained. The place of employment should be as safe as the exercise of reasonable care and skill permits. It's not enough for an employer to show that the danger on the premises was known and fully understood by the employee. The duty extends to and from the place of work, even if the employer is not in occupation of the access route. This is demonstrated in the case of Smith and National Farmers. In that case, a non-delegable duty was owed to an employee who had slipped on compacted snow when leaving her place of work. There was no occupier's liability in that case because the accident occurred on a public highway, so it was a public liability case. Now, a place of work which is safe in construction may become unsafe through some obstruction being placed on it or through the presence of something on the floor which makes it slippery. Now, in such cases, the test to be applied is whether a reasonable employer, in the circumstances of the case, would have caused or permitted the existence of the state of affairs complained of by the claimant. Now, in the case of Latimer and AEC, following heavy rainfall, a factory floor became slippery from oil which was usually contained in a channel. Now, sawdust was put down, but not enough, regrettably, from the claimant's point of view, to cover the whole of the floor, and a workman slipped and was injured. And it was held there was no breach of duty. The test enunciated in that case, I set out there, has it been proved that the floor was so slippery that remedial steps not being possible, a reasonably prudent employer would have closed down the factory rather than allow his employees to run the risks involved in continuing work. In terms of a safe system of work, overarching obligation, which supports and supplements the other aspects of the personal duty owed by the employer to the employee. At its lowest, it requires appropriate instruction of the workforce as to the safe performance of their allotted tasks. However, with a task of any degree of complexity, it requires the use of a safe system of work, which may involve the organisation of the work, procedures to be followed in carrying it out, the sequence of the work, the taking of safety instructions or precautions, the stage at which they're to be taken, the numbers of workers to be employed and the parts to be taken by them, and the provision of necessary supervision. And in that regard, in terms of supervision, when there's a duty to provide a safe system of work, the employer does not discharge the duty merely by providing it, but must take reasonable steps to ensure it is carried out, which involves the instruction of the employee in the system as well as some measure of supervision. Now, in the case of Amar and Coyle, case decided in 2009, Court of Appeal in that case emphasised that in many circumstances there was a duty on employers to warn employees even of obvious risks. And in that case, Lord Justice Richards states that people are very frequently, if not habitually, careless about the risks which their work may involve. And in his opinion, for that very reason, the common law demands that employers should take reasonable care to lay down a reasonable, safe system of work. So if it's probable that a worker would not have used the safety equipment provided or obeyed instructions to use them, the employer will not be liable. However, where the employer does not instruct the employee as to what equipment to use, and the employee does not trouble to find out, it has been found that responsibility will be apportioned in those circumstances. The employer will be liable if it can be shown that the employee would have made use of the equipment had it been provided. So a safe system of work will often require the employer consideration as to whether the employer had taken or undertaken an adequate and sufficient risk assessment, which I'll come on to. And this is highlighted in the case of, or illustrated in the case of Vale. In that case, an education authority was held liable to a teacher who was injured in an attack by a 14-year-old pupil. The 14-year-old pupil was an autistic pupil. And although the claimant couldn't identify what precise steps should have been taken in order to prevent the attack, this was as a result of a failure to assess the risks posed by the pupil in the light of his behaviour. And a proper risk assessment would have led to the identification of steps which would have avoided the injuries which befell the claimant. Now, in terms of the relevant regulations, these are regulations that are prayed and aid by claimants in the context of an EL case. You will see they're commonly referred to as the six-pack regulations, the management regulations, the workplace manual handling, health and safety display screen equipment, provision and use regulations, and personal protective equipment at work regulations. Now, in all EL cases, up until the enactment of the Enterprise and Regulatory Reform Act, they were prayed in aid, as I've indicated, by claimants in all of these cases. Now, a major change to civil liability for breach of statutory duty, including liability under the regulations, was made under Section 69 of the Enterprise and Regulatory Reform Act in 2013. That came into force on the 1st of October 2013, and it amended Section 47 of the Health and Safety at Work Act 1974, where effectively breach of duty imposed by a statutory provision shall not be actionable except as so far as the regulations under Section 47 provide. Now, the government's rationale for this change was to ensure that a claim for damages for breach of the regulations could only succeed where an injured employee could prove that an employer had been negligent. And this was part, as I understand it, of the drive to reduce the burden of health and safety and the perception that there was unfairness when the regulations in some cases imposed a strict duty on employers, which rendered them liable to pay compensation despite reasonable care having been taken to protect employees from harm. Now, whether the imposition of a stricter form of liability than negligence on employers truly does give rise to unfairness is debatable. It's been suggested that employers are already under a duty to comply with health and safety legislation, since breach of that will normally constitute a criminal offence, and liability to employees should be covered by insurance, which has been compulsory since 1972. Now, as I've indicated, Section 69 repealed Section 4 of the Act, repealed Section 47 of the Health and Safety at Work Act 1974. Before the enactment of the 2013 Act, Section 47 read, breach of duty imposed by the regulations shall, so far as it causes damage, be actionable. And that was amended to breach of duty imposed by the regulations in this case shall not be actionable except to the extent that under the regulations this section so provides. That was addressed in the case of Cockrell and CXK Limited. Now, a case decided in 2018. Now, this case arose from an incident whereby the claimant, upon visiting unfamiliar premises in the course of her duties, fell down a doorstep, suffering injury to her ankle, giving rise to chronic disability. Now, of some considerable importance was the date of the accident, which was the 1st of October 2013, which was the day the Act came into force. Now, the claimant in that case brought proceedings against her employer, CXK, and also the occupier of premises known as Artwise. And the case was tried on liability only. Parties were agreed that the effect of Section 69 of the Act was no longer a freestanding cause of action available to the claimant for any breaches of the statutory duties, the six-pack regulations, and the only route open to the claimant against her employer was common law negligence. And in that regard, the claimant invited the court to consider the duty to assess risks under Regulation 3 of the management regs, and also Regulation 12 of the workplace regs. Now, the Deputy High Court judge, and I set out the quotation there, and she highlights the effect of Section 69, which amends Section 47, and the case proceeded on the basis that there was no longer a self-standing cause of action available to the claimant for any breaches of the statutory duties, and the only cause of action against CXK lay in common law negligence, that is to establish that the common law duty of care owed to her by her employer had been breached, and that breach had foreseeably caused an accident. She then went on. Second source was the statutory health and safety regime itself. Claimant's case, and again not disputed, was that in considering the nature of the modern common law employer's duty still permissible to have regard to the statutory duties. And she goes on in paragraph 18, care is needed with this analysis in removing the claimant's cause of action for breach of statutory duty. The 2013 Act did not repeal the duties, and those duties continue to bind employers in law, so they continue to be relevant to the question of what an employer ought reasonably to do. However, the enactment of Section 69, Parliament intended to make a perceptible change to the legal relationship between employers and employees, and it removed the direct actionability by the claimants from the enforcement mechanisms to which employers are subject in carrying out those duties, and what she'd referred to as the rebalancing. And you can see that Section 69 was evidently directed to ensuring that any breach of those duties would be actionable by claimants, but only if it also amounted to a breach of duty of care owed to a particular claimant in any particular circumstances. Or in other words, if the breach itself was negligent, it's no longer enough to demonstrate a breach of the regulations. So in terms of the impact, burden of proof, that is, that it was practicable to take precautions, effectively shifts to the claimant, whereas under the regulations, the burden of proving that it wasn't practicable or not reasonably practicable to take precautions generally rested with the defendant, employer, and in a negligence action, the employee will have to establish this as part of proving that the employer took an unreasonable risk. So to summarise, the 13 Act had a radical effect on liability of employers to their employees. So from the 1st of October, breach of duty imposed by the regulations should not be actionable except insofar as Section 47 provided. However, and this reversed the previous position under the Act. So in that regard, a considerable body of case law has built up concerning the regulations, and these general issues may remain relevant to some extent, since the health and safety regulations will often remain relevant to employees' actions and negligence. And breach of the regulations will normally constitute a criminal offence. Negligence sets a standard of reasonable care in the face of foreseeable risk of harm to employees. And many of the health and safety regulations require employers to take such precautions as are practicable or reasonably practicable. And if an employer is in breach of the regulations, it may well be difficult on the part of an employer to argue that it has nonetheless acted reasonably whilst at the same time, for example, committing a criminal offence, an offence created by Parliament specifically for the protection of health and safety of employees, and which can be seen as setting the appropriate standard behaviour. So the differences are apparent in that the burden of proof that it was practicable will effectively shift to the claimant, and under the regulations, that burden rested with the defendant. And in a negligence action, the employee will have to establish this as part of proving that the employer took an unreasonable risk. In terms of the standard of care, taking reasonable care is a question of fact in all the circumstances. The standard of care required has been described as high, but this means no more than the precautions required vary with the circumstances of the case, and the dangers involved in a work situation may require considerable care. Now, the common practice of other employees in the same work areas is said to provide some guidance. In the case of Thompson and Smith ship repairers, this was a deafness case. In that case, it was held that where there had been a long practice of inaction with regards to the possibility of deafness through industrial noise, the defendants were only liable for a failure to take steps once that awareness of the danger and protective equipment had become available to the employer. However, the employer must also allow for the fact that employees may be inadvertent or become heedless of the risks, particularly where they are encountered on a regular basis, which will involve the taking of reasonable steps, not only to instruct employees on safety procedures, but also to ensure that procedures are followed. Now, the classic test for employers' liability for common law negligence is embodied in the dictum of Mr. Justice Stanwyck in the case of Stokes and Guest. Set it out there. From these authorities, I deduced the principles that the overall test is still the conduct of a reasonable and prudent employer, taking positive thought for the safety of his employers in the light of what he knows or ought to know, and where there is a recognised and general practice which is being followed for a substantial period in similar circumstances without mishap, he is entitled to follow it. It then goes on, where the employer has in fact a greater than average knowledge of the risks, he may thereby obliged to take more than average or standard precautions. Employer must weigh up the risk in terms of likelihood of injury occurring and the potential consequences if it does, and the employer must balance this against the probable effectiveness of the precautions that can be taken to meet it and the expense and inconvenience they involve. And if he is found to have fallen below the standard to be properly expected of a reasonable and prudent employer in these respects, he is negligent. And in Thompson, again, I set out the passage from the judgment. One can see there that not one employer is exonerated simply by proving the other employers are just as negligent, but that the standard of what is negligence is influenced, although not decisively, by the practice in the industry as a whole. So in the context of a hospital, for example, where the employer also owns duties to other parties, for example, patients, complex questions may arise concerning the nature of the duties to employees and others, and the context of the duty owed to the employee may, in principle, be quite different from the content of the duty owed to others. And so, where knowledge of the risks to employees within an industry is developing over time, issues will arise as to when an employer's knowledge has reached the point which it would be unreasonable to fail to take precautions against the risk, and whether different employees are subject to different criteria. Case of Baker and Quantum, which I think got to the House of Lords, if not the Supreme Court, in that case, the question was when it would have been reasonable to expect an employer to be aware of the risks of deafness from exposing an employee to noise between 85 and 90 decibels. In that case, the 1972 Code of Practice gave 90 decibels as the maximum figure that an employee could be exposed to. And it wasn't until 1987 that it became apparent that lower levels than that stated in the Code of Practice might also be harmful. In the Supreme Court, the majority said that an employer could generally rely upon the Code of Practice and not provide protection against the lower levels unless the situation was one where there was developing knowledge about the risks involved and the employer had a greater than average knowledge of the risks. Now, in such circumstances, the employer would be treated differently from the average employer in that they were required to act on the knowledge that they actually had, even though this appears to penalise employers who, and I quote, who have a safety department and medical officers to take noise more seriously than the ordinary reasonable employer. Now, in the case of, in terms of a duty to conduct risk assessments, this is highlighted in the Supreme Court of Kennedy and Cordia, the brief facts of which are the appellant, Miss Kennedy, the claimant, was employed by the respondent Cordia Services as a home carer in Glasgow. Now, Cordia were wholly owned by Glasgow City Council, and they provided home care services on its behalf. Those services were previously provided by the council itself. Now, the claimant's principal duty was to visit individuals in the homes and to provide them with personal care. In December 2010, the claimant was required to visit an elderly lady who was terminally ill at her home in order to provide her with palliative and personal care. Now, the visit was one of a series of visits carried out by the claimant during her shift, and she travelled to the patient's house after visiting another client. Now, at the material time, there had been severe wintry conditions in central Scotland for a number of weeks prior to the date the claimant had her accident. There was snow and ice lying on the ground. The claimant was driven to the house by a colleague who parked her car close to the public footpath leading to the house. Footpath was on a slope which was covered in fresh snow which overlaid ice which hadn't been gritted or salted. Claimant at the material time was wearing flat boots with ridged soles, and after taking a few steps along the footpath, she slipped and fell to the ground, injuring her wrist. Now, Cordia were aware of the risks the home carers might slip and fall on snow and ice when travelling to and from clients' houses in the winter, and on average 4 such incidents had been reported to them or the predecessors, the council. And that was during each year since 2005. And during 2010, there had been 16 such incidents. Cordia were also aware of the snowy and icy conditions on the night in question, as those had persisted for a number of weeks. Now, in 2005, the council had carried out a risk assessment in relation to home care services and client care, and it covered the risk of travelling to and from work locations. And a further risk assessment was carried out by Cordia in 2012, which didn't specifically consider the risk of injury from slips and falls in inclement weather, but otherwise was similar in terms to the 2005 assessment, although neither assessment considered the possible provision of personal protective equipment. Now, the Supreme Court emphasised that it become generally accepted that a prudent employer would conduct a risk assessment in connection with its operations so that it could take suitable precautions to avoid injury to employees. And the requirement to carry out such an assessment, whether statutory or not, formed the context in which an employer had to take precautions in the exercise of reasonable care for the safety of its employees. And the Supreme Court emphasised that the duty to conduct a risk assessment was logically anterior to determining what precautions a reasonable employer would have taken in order to fulfil his common law duty. So effectively, all steps taken by the employer predicate upon what is contained within the risk assessment. So the significance of this is that an employer's duty at common law in relation to admissions, in the case of Kennedy, the omission to provide protective footwear to reduce the risk of slipping on ice and snow, was not confined to taking such precautions as are commonly taken or which would be taken by anyone. The employee working away from the employer's place of business was not in the same position as everyone else, as they had less choice about whether to encounter risks. And at common law, the employer had a duty to seek out risks and to inquire into the possible means of reducing the risk. And if these inquiries had been made in the case of Kennedy, Cordia would have discovered that attachments to the footwear were available at a modest cost, which would have reduced the risk of slipping, and that other employers had provided them. Now, in Cockrell, it was emphasised, relying on the case of Kennedy, that risk assessments played a significant role in the content and discharge of an employer's duty of care, and that the regulations required this remain relevant even when they did not themselves create an actionable duty, and we've discussed this. Decision of Cockrell is important in the light of the 2013 Act. In the case of Cockrell, the employer had not conducted its own risk assessment, but had relied upon an existing risk assessment in relation to premises which it had hired on a short-term basis, and on those facts, it wasn't negligent. In the case of Birch, the absence of a risk assessment in relation to scalding injuries from a boiler had created a lack of evidence as to whether the limited annual process of testing the water temperature when the boiler had been serviced adequately met the risk of scalding. When a scalding injury occurred to the claimant, the conditions for the application of the Latin maxim res ipsa loquitur, which you may or may not know means the thing speaks for itself, was satisfied, and the employer, who was unable to offer any evidence in rebuttal, was held liable. Significance of risk assessment for the analysis of breach of duty of care at common law was also illustrated in the case of Castles. In that case, the deceased had been run down in it by a coach while greeting the vehicle in a car park in the course of her employment. Second defendant's risk assessment had not considered this risk, and this had been a negligent omission, and but for it, the accident would not have happened. The fact that after the incident, a risk assessment was broadened to include the risk that did eventuate did not imply that the original omission of the risk assessment was negligent. This would be to judge, as the judge found, to judge the issue with hindsight. In the case of Shelbourne and Cancer Research, an employer had not been negligent in failing to include in the risk assessment the possibility that an inebriated employee would act dangerously on the dance floor at an office party. And so context is all important. And in that case, previous parties had not given rise to any similar behaviour. And in the case of Shell, it was accepted that in the context of the claim, it would not have been reasonable to expect the employer, in that case, the employer took health and safety very seriously, to extend the extensive site risk assessment to include horseplay, ill discipline and malice in a case where the worker had been injured following a pointless practical joke by a fellow employee. So after the event, I've touched on after the event, what steps taken by the defendant and are they relevant in the circumstances? Case of Goldschneider, another deafness case. In that case, the claimant was a viola player and worked at the Royal Opera House. And in the 2012 season, it opened with Wagner's Ring cycle, in which 90 orchestra players occupied the pit. The viola players, as I've indicated, the claimant being one, was positioned directly in front of the brass section. Claimant was given 28 decibel earplugs, so the earplugs that would offer noise attenuation up to 28 decibels. The sound was still excruciatingly loud and painful. To such an extent, complaints were made by the viola players and the noise levels of 91 decibels were recorded. By the end of the third day of rehearsals, the claimant had suffered injury to his hearing, which ended his professional career. At the subsequent rehearsal, the claimant had left. The orchestra was rearranged to give a 1 metre space between the viola and brass section, which was also split up, but the noise level was still recorded at 82 decibels. Now, a first instance, Mrs. Justice Davis ruled the Royal Opera House had breached the duty under the noise regulations of 2005. Effectively, the risk assessment didn't take into account the requirements of the regulations, and the defendant had failed to take all reasonably practicable steps to reduce the risk of noise level to the lowest level reasonably practicable. Defendant appealed, but was dismissed. And it would appear the defendant took steps following this particular incident. You can see Mr. Justice Leveson. Alterations made by the defendants after a workplace accident do not necessarily demonstrate liability retrospectively, but they do make it very difficult for the defendant to prove that all reasonably practicable steps had already been taken. Now, in the case of Books and others, case 2006, very briefly, 6 claimants employed by the defendant's predecessors as psychiatric nurses at Rampton Hospital, which was one of 3 high-security hospitals for persons liable to be detained under the Mental Health Act. Claimants, in March 2001, the claimants were all working a night shift. 4 of them were working on a ward containing 14 patients, one of whom had a prolonged history of extreme violence. Normally, there would be 5 staff on duty on that ward, but only 4 were available on this particular night. And the claimant's request for another member of staff was refused. During the course of the night, the patient approached the staff and seriously injured one of them, and the other 5 claimants were each assaulted by the patient as they tried to restrain her. Now, there was a publication in February 2000 of a report on security at high security hospitals, as a result of which the Secretary of State had issued directions in 2000 to 3 high security hospitals, which came into force in November 2000, which required each patient be assessed as to whether he or she posed a security risk, including a risk of assault, and that a risk management plan be devised for each patient. And each hospital was also to have a policy in place on the circumstances in which the patient considered to be high security risk could be locked into his or her room at night. And in breach of the directions, Rampton failed to devise and implement such a policy. Claimants sued for damages alleging insufficient numbers and a failure to have confined the patient to her room. Liability tried as a preliminary issue in that case. Judge found that an extra member of staff would not have prevented the assaults, and so the claim based upon insufficient staff could not succeed. However, we found the patient presented a plain and obvious risk of assault and ought to have been confined to her room at night in line with the policy, which the directions had required be implemented, and the failure to have her confined was negligent. Defendant appealed on grounds that there was no evidence that the risk posed by the patient was greater at night. In fact, they were less. And the duty owed by the claimants had to be balanced against the duty owed to the patient, which was governed by Boland principles. And accordingly, the hospital could not be negligent unless it could be shown that no reasonable body of clinicians would have failed to confine the patient. Now, the Court of Appeal dismissed the appeal effectively on the basis that although the evidence did indeed suggest the risk posed by the patient at night was less than during the day, it was still unacceptably high, and confinement was merited. And what the employer's duty of care requires must take into account sometimes competing duty of care owed to the patient, but isn't subject to it. Just because it might not have been in breach of duty of care owed to the patient to confine her or not at night, this did not mean that it was not a breach of duty owed to the employees not to confine her. So there were competing arguments in that particular case. In that case, reference was made to the case of King and Sussex, where Lady Justice Hale, as she then was, you can see the dicta there. Towards the end of that quotation, you can see an employer owes his employees a duty to take reasonable care to provide safe equipment and a safe system of work, which includes assessing the tasks to be undertaken, training in how to perform those tasks as safely as possible, and supervision in performing them. And similarly, later on, effectively, she draws an analogy and then goes on. It doesn't mean that the employer can expose their employees to unacceptable risks. They have the same duty to be efficient and up to date and careful of their employees' safety as anyone else. It doesn't mean that what is reasonable may have to be judged in the light of the service's duties to the public and the resources available to perform those duties. In the case of Cook and Bradford, this was a case which concerned an employee in a psychiatric hospital being injured, again by a dangerous patient. The patient in that case was in a seclusion suite, and the claimant was injured when a decision was made by two healthcare assistants to allow the patient to come out of the seclusion suite whilst the claimant was standing in the observation area. And Lord Justice Schliemann states there is no avoiding exposing employees to risks. Manifestly, the closer your dealings are with the patient, the greater the risk. If your function is merely to bring coffee on this particular occasion, there is absolutely no need for you to be close to the patient. So the judge held. It seems that she had effectively fulfilled or could have fulfilled her function. One does not know the detailed finding on that, but for my part, I see nothing wrong in the approach which is being taken by the recorder. In the case of Threlfall, this was a case where Lady Justice Smith emphasised the connection between a duty to conduct a risk assessment, which in that particular case was pursuant to the personal protective equipment regs, and a duty to provide suitable equipment pursuant to Regulation 4 of the regs. And for equipment to be suitable in accordance with Regulation 4, it had to be at least appropriate for the risk, and so far as practicable, effective to prevent or adequately control the risk. And the identification of the risk is therefore essential to the judgment of suitability. And in that case, it wasn't open to the judge to base the assessment of the suitability of the equipment on inadequate risk assessment by the employer. In that case, the claimant had suffered lacerations to his hand from a concealed sharp object when clearing garden refuse, been supplied with ordinary gardening gloves which could not protect from such lacerations. And although the risk of such lacerations wasn't high, it didn't mean that the gloves could be said to be suitable. Gloves which would protect against lacerations were available, albeit at a greater cost. Lady Justice Smith said the adequate risk assessment would have considered the risk of laceration from sharp objects, and the suitability of the equipment should be judged accordingly. So in general terms, Lady Justice Smith described the difference made by the statutory duty and health and safety duties in terms of a duty to anticipate and guard against risks. And I set out the quotation there. In many instances, a statutory duty to conduct a risk assessment has been imposed. Such a requirement, whether statutory or not, has to a large extent taken the place of the old common law requirement that an employer had to consider and take action against those risks which could reasonably be foreseen. The modern requirement is that he should take positive thought for the risks arising from his operations. In terms of assaults on patients on staff, there's very little in the way of jurisprudence on this. There's not a great deal of cases, but it emphasises the need to carry out a risk assessment. It highlights the importance of appropriate training to ensuring employees follow that training. It also emphasises the importance of maintaining a safe system of work and ensuring care plans and care records are available to staff and kept up to date. In terms of needle stick injuries, I've taken this from the NHS Resolution website. There was a great many, 2,600 claims for needle stick injuries between 2012 and 22. 1,947 successful claims, which cost the NHS over £10.5 million in terms of damages and costs. Of those sums, 1,460 were received from ancillary workers, including cleaners, porters, laundry, maintenance staff. And you can see the breakdown of the other claims. Guidance is given in that regard. So in terms of employee training, need to check training on correct disposal procedures is up to date, review the organisation, procurement of safer sharps versus conventional sharps, consider why you're not using safer sharps. Is it a habit or lack of awareness? Check training is implemented on the safer use of sharps. And there is a hierarchy of guidance given in the health and safety Sharp Instruments and Healthcare Regulations 2013. In terms of the health and safety of executive, again, guidance is given there. As an employer, you need to take action to manage the risk if the workers use sharps or provide care to other services, provide care to all other services to people who are likely to use sharps, are involved in handling such equipment after use, and are likely to inadvertently come across sharps, for example, during laundering. Again, guidance is given there. Must assess the risks, identify the hazards, consider the nature of the work, evaluate the risks, and implement, monitor, and review control measures to reduce the risk. So in accordance with what I've been discussing earlier, the guidance follows the points I've made. In terms of completing the risk assessment, needs to be appropriate for the nature of the work. The more hazardous the work, the more in-depth the assessment should be. For example, procedures that have a higher risk of injury, including intravascular cannulation, you'd have to consider that. Who completes the risk assessment and to whom it applies will depend on the nature of the work, in the complexity of the organisation. So in acute hospitals, a generic hospital-wide assessment may well be suitable, where the activity and type of sharps is common across the organisation. In a small GP practice, again, a generic assessment may well be suitable. In an operating theatre, it tends to be more specific. And implementing control measures, there is a hierarchical approach recommended in the COSH regs, and I set out some of the factors to be included. In terms of preventing the risk of exposure, primary duty is to prevent exposure to the risk of sharps injury, and if the risk cannot be prevented, then the risk must be adequately controlled. And then there's a hierarchy. One can see the design and use of appropriate work processes, systems and engineering controls, and provision of suitable work equipment and materials, control of exposure source, having clinical waste policy, which ensures safe collection, and where adequate control of exposure cannot be achieved by other means, provision of suitable PPE. In terms of information, instruction and training, responsibility clearly falls on the shoulders of the employer, which should cover biological agents employees could be exposed to, the findings of any risk assessments, the precautions to be taken by employees, how to use any personal protective equipment, and what procedures to be followed in the event of an emergency. In terms of slips and trips, as you may or may not be aware, it's governed by the Occupiers Liability Act, Section 2. Section 2.2, you can see that common law duty of care is a duty to take such care as in all the circumstances of the case is reasonable to see that a visitor will be reasonably safe in using the premises for the purpose for which he is invited or permitted by the occupier to be there. Section 3, circumstances relevant include the degree of care and want of care, which would ordinarily be looked for in such a visitor, so that the occupier must be prepared for children to be less careful than adults, and an occupier may expect that a person in the exercise of his calling will appreciate and guard against specific risks. Now, factors to be taken into consideration. So in determining whether the occupier of the premises discharged the duty, regard is had to all the circumstances. I think that those are the crucial words in the statute. And goes on, so that, for example, where the damage is caused to a visitor by a danger of which he had been warned by the occupier, the warning is not to be treated without more as absolving the occupier from liability, unless in all the circumstances it was enough to enable the visitor to be reasonably safe. In that regard, as I've indicated, all the circumstances of the case of White Lion Hotel, I won't go into the facts of that case, but Lady Justice Davis effectively indicates the assessment of whether there's liability under Section 2 in a tripping and slipping case is essentially a factual assessment based on the particular circumstances of the case. So common law duty of care is more than a duty to avoid negligent acts. It extends to negligent admissions as well. So not only must the occupier avoid creating dangers, he must also take reasonable steps to protect the visitors from dangers which he himself did not create, as where he fails to warn of a hazard or not otherwise apparent, or to take steps to remove the danger. There must be some danger arising from the defect in the state of the premises. It should be noted that even if the defendant is at fault in providing unsafe premises, alone be liable for the injuries likely to result from a particular feature. Now, the burden of proof in these cases lies with the claimant, and in that regard will be had to foreseeability of injury, how obvious the danger was, the age of the visitor, the purpose of the visit, and the conduct to be expected of them. Sorry, I'm racing through this. Also of considerable importance is the difficulty and expense of removing the danger. It's a relevant factor, as is the time in which the reasonable occupier may be expected to highlight and deal with the hazard, the practice of occupiers generally, and any relevant official or semi-official rules, presence of a reasonable system for dealing with possible dangers such as regular patrols, powerful indicator, any duty of care has been satisfied, and the court is entitled to taking into account the likelihood of danger materialising, and a failure to carry out an adequate risk assessment may well tip the balance in favour of liability. Very briefly, case of Warden Tesco. In that case, the claimant was shopping in Tesco in Liverpool in 1975. There was some 30 to 35 members of staff present at the time. She walked down the aisle. She slipped on some yoghurt which had been spilt on the floor. The yoghurt pot was found nearby. About 3 weeks later, she returned to the store, gave evidence that she'd observed some spillage of orange juice on the floor for 15 minutes before anyone had cleared it away. Defendant called evidence about the cleaning procedures at the store. It was brushed 5 or 6 times during the day, and if spillages were identified, someone would stand by them. But it was unable to say when the store had last been cleaned before the claimant's accident. The store manager accepted there were approximately 10 spillages a week. Defendant contended that it was for the claimant to demonstrate that the yoghurt had been on the floor long enough to be identified and cleared away. Unless she could do so, there was no case to answer. Leading judgment was given by Lord Justice Lawton, and can see that if an accident does happen because the floors are covered in a spillage, then in my judgment some explanation should be forthcoming from the defendants to show that the accident did not arise from any want of care on their part, and in the absence of any explanation, the judge is the judge may give judgment for the claimant. Such burden of proof as there will be on defendants. Pausing there, appears to suggest that there is a burden on the defendant. A similar judgment by Lord Justice McGaw, one can see there. The defendant could escape from liability if they could show that the accident must have happened, or even on the balance of probability would have been likely to happen, even there had been in existence a proper and adequate system in relation to the circumstances. But if the defendant wished to put forward such a case, it's for them to show that on the balance of probability, either by evidence or inference from the evidence that is given, the accident would have been at least equally likely to have happened. However, there was a dissenting judgment in that case by Lord Justice Ormerod. One can see the accident described by the plaintiff, and she did no more than describe the accident, that she slipped on some yoghurt which was on the floor of the supermarket, could clearly have happened no matter what degree of care these defendants have taken. The crucial question is how long before the accident the yoghurt had been on the floor. Had some customers knocked it off the shelf before, then no reasonable system which the defendant could be expected to operate would have prevented this accident. So I think the plaintiff falls at the outset. Now this reasoning was followed at Furness and Midland Bank. On that case, the claimant slipped on water on a flight of internal stairs in an office block where she worked. Steps were constructed of smooth tiles, no evidence about how long the water had been present, nor where it had come from, no history of leakages or spillages, and the defendant adduced evidence of periodic inspections of the general structure of the building and routine clearing of the staircase at the end of the working day, although there was no evidence of any regular clearing of the staircase during the course of the day. Claimant invoked Warden Tesco, and you can see that was disavowed to a certain extent. You can see the second paragraph. In a case as the present, where the spillage and leakage is almost unheard of, and where the premises are used only by employees, it seems to me absurd to think that an instruction of the sort suggested here would in reality serve any useful purpose. And again, in the case of Laverton, that was a case where the claimant slipped on rainwater in the defendant's takeaway shop in the early hours of the morning. Rainwater had been brought in on the soles of customers' shoes. Claimant argued that Warden Tesco should be the starting point. That was rejected by Lady Justice Hale. And she sets out, the judge in this case found it unnecessary to resort to Ward. And in my judgment, he was right not to do so. No question that the floor was wet. The issue is what it is reasonable to expect a shopkeeper to do about it. There is a distinction between particulars that are dangers such as greasy spillage, which it is reasonable to expect a shopkeeper to deal with straight away, and the general problem posed by walked-in water on a wet night, which can never be completely avoided. Everyone coming in from the wet outside to a drier inside brings water with them. As I indicated at the outset, I can deal with these three very short order because I think we've just got slightly over. In all of these cases, the issue of contributory negligence is relevant, which is dealt with by the Law Reform Contributory Negligence Act. What is contributory negligent? Again, Froome and Butcher. Forgive me. Case of Froome and Butcher, which is a case for a failure to wear a seatbelt. There is a previous dicta there from Lord Denning. You can see the negligence depends on the breach of duty, whereas contributory negligence does not. Negligence is a man's carelessness and breach duty to others. Contributing negligence is a man's carelessness in looking after his own safety. Guilty of contributing to negligence if he reasonably to have seen that if he did not act as a reasonably prudent man, he might hurt himself. So examples given there are not following training, for example, disregarding obvious dangers, failure to be alert to dangers, and of the sort. They are normally predominated in cases of this nature. I think that may well. My apologies for racing through the latter part of that, but I think I've covered all the slides there. I know there's provision to ask questions, and thankfully nobody has typed up any questions. So with that, thank you for listening to me, and I'll hand you over to Ian.
Thanks, Doug. We did give you a very wide range of issues to cover, so thanks for doing that very comprehensively. All the attendees will receive a follow-up email, which will give you these slides, so obviously you can refer back to those and the detail of the cases, etc. within them. I mentioned feedback. Please do complete that if you can. And if there were any burning questions that you haven't been able to get to today, then please do send those to me and we'll get back to you on those. Otherwise, as Doug said, given we've slightly run over, thanks all for attending today. There is a third in the series, again, that will be in the follow-up email with a link to register for that as well. And that will address issues such as vicarious liability, non-delegable duties, and fundamental dishonesty. So still nothing in the Q&A. So thank you very much for everyone for attending, and we'll leave it there.
Thank you.